to the governor's.
That's right.
Earlier.
That's right. Now, I put it like this. He has made a complaint. He seeks sanction. Governor grants sanction. It's not a suo motu governor action. The governor action is based on on XYZ's complaint. That complainant says not necessary. Well, then, obviously, since he will not withdraw it, your lordship should, treat that application for sanction as non-existent on this basis alone, on the counter affidavit. And therefore, the basis and the foundation of sanction goes. We are not here to answer academic questions. We are not here to, the entire foundation of the sanction order goes. And this is not, this is a person who is facing this, like me, the petitioner, has every right to say this is absolutely a farce. I didn't mean it lightly when I said the governor should, before sanctioning prosecution against me, impose costs against him. If he has the power, certainly your lordship has the power. I don't know if the governor has power to impose costs. So this is the short point on which on the second aspect of 17A, and it's a full point, I submit with respect, that this cannot be just that you come to system, you set a whole thing in motion, and then you say not required at all. Well, then you have to be straight in your stand. You take your chances. What is the problem? You go ahead, prosecute, we'll see whether sanction is required or not. You can't have it both ways. You get a sanction, when I come to court, you tell the court in the counter affidavit, I didn't require a sanction.
Don't you mean to say that they can proceed with it without sanction?
They should. They should, They should have the courage of their convictions. I'm not saying anything. I'm only defending. Imagine, that's why we say, that's why. No, there's another facet to it. In practical, not in law also, people like the governor should be restrained. That's what happens when anybody walking about the path makes an application. Should not the governor have said that you don't require sanction? If you applied your mind. I'm not saying he would have or should have. But anybody on the road comes to him and says, give me sanction. He's so eager to give the sanction, the man himself says, no, I don't need sanction.
No, but approval under 17A is not sought prior to all actions. It is when the court proceedings were on, I guess, after the complaint being before the court.
Yes.
The approval is sought at the hands of the governor, not before that.
No, it's
when was the complaint registered?
First, the sanction was sought.
Amal complaint registered.
Right at the threshold. And your lordship, 3 mandatory judgments are prior sanction. So, this is very serious. He's playing ducks and drakes, A, with the governor, who has actually granted his prayer, and B, with the court. And the only legal consequence of this is, of course, I'm not saying that he's going to withdraw, should be his withdrawal on the basis of his affidavit. He can't, the affidavit prevails. Perjury prevails on an affidavit. He can't be perjuring himself by filing the affidavit before your lordships. So on that affidavit, he must withdraw. Otherwise, your lordship should treat that as non-est. The moment it becomes non-est, the sanction goes. So that's the ground for the sanction to go. It's not a suo motu sanction.
No, it's not.
Now, the other person, like Alice in Wonderland, gets curiouser and curiouser. That is the phrase used in that book. It's quite remarkable what happens in the other case. That is Mr. 4, R4. He has got sanction also from the governor. Your lordship has got an order. The final order mentions, suddenly, notice came to me only for R3. That's why
a particular paragraph mentions these two as well.
These two also. So the governor is purportedly applying might to 4 and 5 also. But it now transpires that R4 never sought sanction. The other fellow says, I need not have sought sanction, but I did. I hope I'm clear. If you actually examine R4's complaint, which has now come to me, and I'm going to ask my learned friends better equipped in Karnataka to read it to your
Maybe some restraint, my lord, on
Wait,
usage of words.
when sin is submitted, wait.
I'm going to ask you to read it.
Anything I'll ask you.
No, my lord. On usage of words, my lord. There may be some restraint.
About
my lord.
what?
Some fellow, Alice in the
that-
Wonderland.
yes.
My lord,
Sorry.
it's not, my lord. There's no impediment for me to use such words.
Yes.
But protecting the sanctity of this honorable court is utmost important.
If
The-
literature of Alice in Wonderland
It's not a revenue
standards
court,
are
my lord.
objectionable,
it's
unparliamentary words, I
it's
plead
such
guilty.
language.
I plead
You may
guilty.
address them as respondents, that's all. Yes.
Now, Malas, we are in a case where the first person says that I applied for sanction, but I need not have applied, which is sufficient to allow the sanction to fall.
All right.
The second person says, I never applied for sanction. Then how did the governor grant on
But
what?
he has not applied. That is a fact.
That's fact. Now, we'll just see that. Just see that at 376, his application. It's quite remarkable. 5th of July,
Whose
2020,
application?
R4s.
Now find that.
To the governor, which is now, well, we have got only well, with this reply,
76 of what?
376 of R4's objection.
R4 objections, madam. R4 objections. Yeah.
Now, Milits, I made them read it to me slowly, and I was happy to note that I could understand most of the slow reading of Kannadiga. But I can't read it to your lordship, so my learned friend Mr. Ravi may kindly do the honor of reading.
This
just
is
the
this
last
Snehamayi Krishna. R4 is it?
R4. The last, just the relevant portion.
Just subject and
Yes.
the prayer.
First is the subject words. Yes.
376. 376.
I'm sorry, I should have Kannada.
All
I
right.
only said Kannadiga.
Hey, read.
Kannada.
In your subject ನೋಡಿದೆ.
Apologies.
Kindly come to prayer.
ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು
380.
ಅದೇ ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು
Yes.
Hmm.
I'll read it.
Yes.
My learned friend is also able to understand Kannada. When they read it slowly.
No, I understood it when they read to me slowly in conference. I understood most of it. I was happy to note.
Yes, sir.
ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು ನಾವು ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿ ವಿಜಯನಗರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ನಾನು ನೀಡಿರುವ ದೂರರ್ಜಿಯನ್ನು ಆಧರಿಸಿ ಕೂಡಲೇ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿ ಸದರಿ ಪ್ರಕರಣವನ್ನು ಸಿಬಿಐಗೆ ವಹಿಸುವಂತೆ ಹೇಳಿ ಮಾಡಿ ಸಿಬಿಐಗೆ ವಹಿಸುವಂತೆ ಪೊಲೀಸ್ ಮಹಾನಿರ್ದೇಶಕರು ಮತ್ತು ಪೊಲೀಸ್ ಮಹಾನಿರೀಕ್ಷಕರಿಗೆ ಸೂಕ್ತ ಆದೇಶ ಮಾಡಲು ಹಾಗೂ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳ ಮೇಲೆ ಪ್ರಭಾವ ಬೀರಿ ಮೊಕದ್ದಮೆ ದಾಖಲು ಮಾಡದಂತೆ ಮಾಡಿರುವುದನ್ನು ಸರ್ಕಾರಿ ಯಂತ್ರವನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸುಳ್ಳು ಮಾಹಿತಿಗಳನ್ನು ನೀಡಿ ತಾವು ಮತ್ತು ತಮ್ಮ ಕುಟುಂಬ ಯಾವುದೇ ಅಕ್ರಮ ಎಸಗಿಲ್ಲ ಎಂಬುದನ್ನು ಸಾಬೀತುಪಡಿಸಲು ಪ್ರಯತ್ನಿಸಿರುವುದನ್ನು ಗಮನಿಸಿದಾಗ ಸದರಿ ಪ್ರಕರಣದ ಮೇಲೆ ಮುಖ್ಯಮಂತ್ರಿಯಾಗಿ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯನವರು ಪ್ರಭಾವ ಬೀರುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯನವರನ್ನು ಕೂಡಲೇ ಮುಖ್ಯಮಂತ್ರಿ ಸ್ಥಾನದಿಂದ ವಜಾ ಮಾಡಲು ಕಳಕಳಿಯ ಮನವಿ ಮಾಡಿ.
Now, it's just this much shows I'm not interested in R4, who has not even filed. It shows complete non-application of mind of R2. Complete, total and absolute on that short ground, the sanction must go.
One clarification. No, 1 minute. One clarification. Here there is, he is not seeking sanction at all here. He's only asking the matter to be referred for investigation to the hands of the CBI. And inter alia, he says that he should step down.
Correct, absolutely.
So this is not a question of sanction at all.
Correct. He goes to the governor passes an order on this. Sends me a show cause based on this.
No, show cause notice is not issued on this.
No.
Not on
No
this.
show cause notice is
Not
issued on
this.
this.
Then Malas, the order says I'm.
A paragraph
That's
refers
right.
to this.
That's right.
But no show cause notice
No,
is issued to you on this.
One of facts. This morning, along with a memo, we have filed a communication dated 31st of July 2024, which we have submitted, my lord, to the honorable governor, which seeks for sanction. Kindly see that memo.
When was that given?
31st of July. This is after this letter, another communication.
Governor's order.
That is what I want to point. So, my lord, to say
Governor refers to this, you mean?
by date, the governor, my lord, does not refer to it by date, but to say that no sanction at all was.
Why you did not file this along with the statement of objection?
No, Malas, I'm very happy. Please let them, Malas, oh, these webs we weave, we become Malas caught in them. Please record this. Kindly record this, Malas. This is an official statement. I'm not talking about counsel, I'm talking about his client. He says he did, so he said this is not, but I filed on 30th or 31st of July. Kindly record that.
Yes. No, anyway, it is getting recorded, not a problem.
No, what I mean to say is not record in that sense, but it's a stand now.
Yes, yes.
Now,
system.
That 31st of July, so my point till I heard Mr. Raghavan intervening was that there is complete non-application of mind by the governor. Now I hear him intervene, possibly to say, no, the governor did apply his mind. But my point remains the same. The governor in his sanction order does not recognize, mention or note 31 July, which I have heard for the first time 1 minute ago. So my non-application of mind is improved. Oh, these webs we weave. That is the point, fellows. That's what Shakespeare said. More you weave a web, the more you get caught in it. So, to try and cure the lack of application of mind by the governor, a statement is made that we did give him a sanction application. The governor doesn't notice that sanction application in the order sent to me and does not issue me show cause on that.
No, all that the governor says at paragraph 2 is
Yes.
2 more petitions from Pradeep Kumar SP and
Yes.
Snehamai Krishna
Yes.
have been received at my office in respect of the same allegations. So date is not mentioned.
three
nor
things,
the
three
content
things.
is mentioned. Yes.
We do not know when given, how given.
So that's what now
Don't
is
know.
sought to be produced.
Now it is produced. It is quite astonishing, to put it mildly. That's my third sub point here. It is more than astonishing that a man who files a 100-page rejoinder forgot to say this in his counter, forgot to say this in his counter. At the moment, I'm trying to use words of studied moderation. We have all been, we are lawyers. Your Lordship has been a lawyer. There are lawyers all over the place here. A person who files a counter yesterday or day before has omitted to mention Hamlet in the Prince of Denmark or Prince of Denmark in Hamlet. But this is his complaint, this is the foundation. Till now, we don't know about it. Your Lordship doesn't know about it. Realizing that he is apparently curing the governor's defect, but not realizing that the governor doesn't tell your Lordship whether he's acting on this complaint which I have read just now or the 31st July complaint. It is quite unclear. He has not, why should I not say that he acted on the complaint I have read to your Lordship and not on this? Why should I not say it? And why is it not fortified by the fact that the first time this has been mentioned is on the 29th of August in the middle of arguments? Well, it's 31st July. When did I argue the matter first? I argued it 1 week ago, I think. 19th August, 31st July, 19th August, 29th August. In between on 27th and 28th August, counters are filed. Well, there are 4 occasions. I'm sorry, Balas, I'm being a
No,
little...
let's see whether the omission would cut at the root of the matter.
It would, Balas, because this is a Balas, your Lordship takes a holistic view. No single straw breaks the camel's back. But Balas, this
Yes.
is very, Balas, to put it in the mildest word is strange is not a good enough word, Balas. This is amazing. And even taking this letter as it is, we do not know on what the governor acted. We are on the ultimately governor's sanction must go. Governor's sanction must go for all these reasons. We have no idea what he acted on, apart from, of course, never sending us a show cause. And that point I had made last time without knowing about this letter.
So you have to say that on this he asked for sanction. Just read the sanction. On this 376 he asked for sanction. Now he is getting intelligent and saying what. Just read.
Now, Malaz,
But one,
let me go.
sorry, one clarification.
Yes.
17A, does it contemplate issuance of a show cause notice against whom sanction is, approval is sought? Does it contemplate?
Well, it's
Application of mind will consider, but the submission that you're trying to make is governor has referred to these 2 and show cause notice was not issued.
it was
That-
issued.
No,
We also
only against
so
one
the
complaint.
principle of issuing R3.
R3's
But the
complaint.
principle of issuing show cause is accepted by the governor himself.
No, true, but whether law requires is what I'm.
Therefore, Malas, I would say yes, natural justice. Your Lordship now, Malas, has, Malas, let me digress for 2 minutes. For the answer, I'll be dealing with it separately. Let me digress. This is a direct question from the bench. I'm obliged to, Malas, digress for 5 minutes and answer.
Yes.
Well, it's not now, but from 1967. Your Lordship has this felicitous phrase, adverse civil consequences in
Yes.
Bina Pani Day.
Yes.
and your lordship did not have very big constitutional principles in 1967.
Yes.
When your lordship elevated saying all this quasi-judicial, judicial, administrative, we go by adverse civil consequences.
Hmm.
That is 67. Now, my lords, your lordship has traveled a distance, two recent judgments, one of which I had the privilege to assist the court. That even, this is exactly the same argument raised, my lords, that before you declare an account fraud, not, my lords, NPA,
No, fraud.
fraud.
That has serious civil consequences.
This
Notice has to be there.
no, the argument was to declare it as fraud is like filing an FIR. You don't need a show cause. There was a specific argument of Solicitor General who opposed me. It's recorded.
That is,
Now, the FIR, you don't require a show cause.
no, FIR you don't require a show
The
cause at all.
argument is that before you declare criminal fraud, an account beyond NPA, you don't need natural justice. And the people in that batch, which we argued, were apparently allegedly owing hundreds of thousands of crores. The court set aside a batch on the principle of natural justice. My answer to my lords respectfully is that natural justice is now elevated to an Article 14. It's now part of Article 14, which is not earlier. Today, my lords, when you do something with very serious, the most serious adverse civil consequences, you are granting sanction to a public servant, in this case, the highest public servant of the
Approval.
state. No.
Oh, sanction is also mentioned.
No.
Yes.
Sanction, oblique approval, let us call it. You are granting to the highest executive of the state, and you are yourself treating as show cause relevant, but you forgot to talk about the other guy. You did have relevance in the first chap. Therefore, you should have dealt with it. On balance, as of today, the law would be interpreted in my favor. But here, I'm on something else. To come back to the point here,
No, I thought it fit to ask you that for the reason that no notices were issued on these two complaints is what you said. That's the reason.
The reason is this,
Yes.
that he felt that he had issued one. The reason is hurry and lack of application.
That's all. Yes.
That's the real answer.
That
Let us be practical. The real answer is that.
Yes.
I got a complaint. I must proceed. So I issued notice on that complaint to him. I got two more. I said, I've already issued a notice for one. I don't bother about all these technicalities of law. Let me pass the order as quickly as possible. That's what has happened.
All right. Well,
But I must now come back to this. This is
yes.
very, very interesting.
I wanted clarification.
No, I'll be
That's
dealing with that. I'll cite Dharampal Satyapal and Rajesh Agarwal. I'll
Yes.
cite those two judgments because the court has gone very far there on natural justice, telling your lordships how important it is. Therefore, there are three. One more thing I want to say on natural justice before I come back to this. There are three categories. Category one is the category where expressly the statute excludes natural justice. There are many statutes like national security, atomic energy
Those,
plants. Your lordships there alone. The second category is where you expressly include natural justice. There is a third category which is the most interesting. The silence of the statute. Your
Then we will have to read into the
in
statute.
Maneka Gandhi, your lordship quoted the very nice words of Hooper versus Wandsworth. The common law will supply the omission of the statute. That's the principle. In the interstices of that gap, you will read in natural justice. And this is, whereas nobody can doubt, is the most serious of adverse civil consequences. So you must read into this. Here the governor has acted on that basis. Only that he has not issued show cause notice on X and Y, but he has issued on Z. So there is no question about it in this case. But let me come back to this intervention by Mr. Raghavan just now.
Yes.
Whereas your lordship will see the number of occasions and how strange this is. You have now, just now told your lordship that I did apply for sanction. Right,
Yes.
Wallace? And this document which Mr. Singhvi is reading is of course not the sanction because I'm reading a document that doesn't seek sanction. Now, Wallace, this document I read just now, I didn't read one friend in Kannada, Wallace,
Yes,
is actually attached to the objections, right, Wallace?
it is.
Now let us see what the objection says. It says this is the application for sanction. This is the problem. When you make up the story as you go along, the problem is this, fellas. Truth has a very strange way, Malas, of getting you caught up in all kinds of webs. Now, let's come to para 55. That was the intervention 2 minutes ago. Now, you should see what your deponent has said.
Para 55.
Yes, page 43.
Mm.
43 of what? sir?
What is BCR?
Objections.
Private complaint filed here. Before
Ah,
trial
where?
court, which is here, the next year before trial court. In the talk of 31/7.
We are now considering a proposition. Just note what are these 4 dates. The original complaint by application by Mr. Ibrahim, that is R3. Then Malas, the application by Mr. R5. Then the order of sanction, sorry, show cause. Then the sanction order. Then Malas, my petition to your lordships and detailed hearing on that. Then 2 days ago counters,
Hmm.
and then today's hearing. In between, there is also police complaint filed, Malas,
Hmm.
PCR. None of them mention 31 July. I forgot to mention on 8th of August, PCR is also filed. I'll
Oh,
give your lordship a list
There is no mention about this.
of this. But the mention in the affidavit, which will prevail on pain of perjury, is this, para 55. We have to go by this, not by Malas, what is said orally. Since the accused one is the present Chief Minister of Karnataka, the competent authority to accord sanction for prosecution is His Excellency. This is the averment to which this is annexed. The competent authority to accord sanction for prosecution is the Excellency. Accordingly, the complainant has also sought for the sanction and permission from the governor under 19, under 55, under 197, under 218, under 200, which is pending consideration. It is pertinent to note that since the allegations against the named accused persons are not in relation to any action taken or recommendation made by accused one or other named accused, there is no requirement of prior permission of approval from the competent authority under 17A. This court can consider the complaint on merits without any legal impediment. The copy of the same is appended as 35. This 35 is 376.
Yes.
Whereas I counted 6 dates from the first date. Again, Wallace, I'm not meaning facetiously. There is a saying,
What is
6.
it? This year is 28, all the rest of documents are there. There's no 37 here.
Give me the date of the application, 2 applications. Whereas in between these dates, write down the dates in a piece of paper. Write it here. In between, on 8th of August, I forgot to mention, a PCR is filed before the trial court. And Wallace, that PCR on 8th of August,
That is where you read from. Para 55 is a part of that complaint.
that's right.
Yes.
It's an X there.
Yeah. No. Now you read 55
Yes,
at page 43 of the objections. That is
That's
a part
right.
of the complaint itself.
that's right.
PCR.
And it is not, Wallace, noted anywhere about 31 July. Stop this.
No. All the documents say there is 37.
And Wallace, the document index, what is this volume?
It's the same R4.
Wallace, this R4's reply has a list of documents which runs up to Wallace serial number 35. You see the list of documents. Obviously, I can't show negative. There is no 31 July whisper of a mention.
That's not there.
Therefore, Wallace, this by itself, Wallace, I'm sorry that these are Wallace, analogies which are arising from the natural course of conduct done by the respondents, not me. There is a saying, the first time it is happenstance. Second